Welcome back to Canadian Justice. I'm chatting today with the Canadian Constitution Foundation's newest lawyer, Josh Dehaas. Now, Josh, in the last segment, we ended by talking about this recent result in the Jordan Peterson case about freedom of expression. For those people who may not have been closely following that sad legal drama, what do you want people to know about the case and why it matters so much for the principles of freedom of expression?
Yeah, so this case it's a big deal. So what happened is the College of Psychologists decided to put Jordan Peterson through some social media training. And they did this because he put out some mean tweets. These were tweets that involved an actor named Elliot Page and a couple other tweets that were critical of, politicos. And the college decided that this was unprofessional and that this caused harm somehow. And so they decided it was okay to discipline them. We just got the judicial review decision, and unfortunately, the court decided that despite Jordan Peterson's right to free expression, the college can go ahead with this discipline. And we think this is a really bad decision because it means if you're a professional like Peterson and you want to get engaged in public debates, off duty, we're talking about as a public figure outside of the practice of psychology or law or medicine or nursing or whatever, you now have to watch more and more what you say, because if you say something that your professional regulator doesn't like, you could be in trouble.
Yeah, I think it's important to remember in a case like this that the regulator, the College of Psychologists, is empowered by the government. They are acting using the authority of the government that's been granted to them through legislation. So the Constitution, the Charter, it applies to this scenario in a way it wouldn't apply in, for example, an employment relationship governing off-duty conduct. So it's a really important case. I think that my concern is that in this case, it wasn't even people Dr. Peterson had made comments about. It wasn't even people who he had ever seen as a patient. It was just general members of the public who weaponized this regulator, had it turned and used it against someone who, it's not even just that they didn't like what they said, it's that they didn't like how he said it. They objected to the language that he used, the rudeness of his tone. And I think that this notion that the government can police our tone through a regulator is a really big problem, and it should send a chill down the spine of every professional in a regulated role. Now, one of the other cases that we are working on at the Canadian Constitution Foundation, which we haven't announced yet that we actually are going to be taking on, relates to Quebec. What can you tell me about that case?
So this case involves a prayer ban. So what happened is in Quebec there were some students praying in schools, and we're talking about public schools here. But some students, for example, Muslim students, pray if they're devout 5 times a day, and so students were going into classrooms and praying, on lunch break or before school or whatever. And Quebec is very concerned about secularism and keeping separation between church and state. And so the education minister reacted by saying, no one's allowed to pray in schools.
Overtly. You can pray silently in your head and no one may know. It's apparently the role of the government to tell private citizens how they may exercise their religion. It's mind-blowing to me. But what are we planning for this problem in Quebec?
So we're planning to intervene. So we want to make some arguments that this is an absolute ban on prayer, and the courts have said that absolute bans are very hard to justify. And we're also going to make an argument about how this is not minimally impairing of the right. It's a prayer ban. The court has often not protected freedom of religion, but when they have, they've said that prayer is a very serious thing to interfere with. And so the government would need a very good justification to, force these kids to leave school if they want to pray. So our plan is to apply for intervener status, and we're hoping that the Quebec court will allow us to come in and assist them with these arguments.
I'm so excited about this case, and my heart goes out to these students of all religions who, if they want to get down on their knees to pray and exercise their religion, they're going to be forced out into the cold and the snow and the rain off of school property. And the practical reality of that on a religious student's life is a really, really serious one. I don't think that the principle of laicite, of official secularism, requires a state to be openly hostile to religious students who are exercising a constitutionally protected right. Remember, this law is not enacted under that Bill 21, which only applies to public servants. This is private individuals. We've got to go to commercial break now, but we will be right back to talk about some of our other cases.